Welcome back. In today's module, we are going to discuss about the trade related aspects of intellectual property rights. Let us see what is there in the outline of the discussion. The outline of the module discusses about introduction to trade related intellectual property rights, objective behind the formulation of TRIPS, nature and scope of the member obligations under TRIPS, why was TRIPS included in WTO, which IP areas are covered under TRIPS, link between TRIPS and WTO, relevance of Doha Declaration for public health, and then we will move forward with this trade related aspects of intellectual property rights. Now, what is this? The Agreement on Trade Related Aspects of Intellectual Property Rights of the World Trade Organization is commonly known as TRIPS Agreement or just TRIPS, Trade Related Aspects of Intellectual Property Rights, in short form is known as TRIPS. It is one of the main agreements of the WTO, which was negotiated as a part of the 8th round of multilateral trade negotiations in the period 1986 to 94 under the General Agreement of Tariffs and Trades, commonly referred to as the Uruguay round, extending from 1986 to 1994. Now, if we want to understand what is the importance of these trade related aspects of intellectual property rights, why it is important, then we can see, like in the general agreements on tariffs and trades, when it becomes open for multilateral trade negotiations, then we can understand with the improvement of technology and the sharing of information, increase in trade practices, there could be many intangible assets, as we saw, which comes under the intellectual properties, could be exchanged between the 2-3 member countries. So, how to deal with those things, to what extent to protect it, and like what all to protect for, becomes important issues of discussion, and TRIPS is related to that. It appears at Annex 1C of the Marrakesh Agreement, which is the name for the main WTO agreement. The Uruguay round introduced intellectual property rights into the multilateral trading system for the first time. The uniqueness of the TRIPS lies in the fact this appears or it applies to all the members mandatorily. You cannot like just say we will not be following it. Now, as we are already discussing what are the objectives behind formulation of TRIPS, let us see what are the objectives. TRIPS was signed or formed with the main objective of, and it is exactly as mentioned in Annexure 1C, desiring to reduce distortions and impediments to international trade and taking into account the need to promote effective and adequate protection of intellectual property rights and to ensure that measures and procedures to enforce intellectual property rights do not themselves become barriers to legitimate trade. So, this is a very important part where we have to see, like this is actually an act of balance when you are talking of, and that is why we are discussing this under ethics, is a sense of balance of where we are like just to all the stakeholders who are connected to it. So, as you can see from the objectives of the TRIPS, it is in one side protecting the intellectual property rights. So, that we are not like encroaching on others' intellectual properties, but also at the same time to ensure to balance that it should not be so much restricted that it becomes barriers to legitimate trade. So, again the question comes here is how to balance between the protection of the rights and also to ensure like the legitimate trades happens and this protection does not act as a barrier to the legitimate trade. Recognizing to this end the need for new rules and disciplines concerning the applicability of the basic principles of GATT 1994 and of relevant intellectual property agreements or conventions, the provision of adequate standards and principles concerning the availability, scope and use of trade related intellectual property rights, the provision of effective and appropriate means of enforcement of trade related intellectual property rights, taking into account differences in national legal system. So, we can see like it is the 3 steps which involves first 3 steps applicability of the basic principles of GATT 1994 and other relevant intellectual property agreements or conventions. So, second is the provision for adequate standards and principles, and third is provisions for effective and appropriate means for the enforcement of trade related intellectual property rights, which is practical in the sense it takes into account differences in the national legal system. So, this is more practical oriented, which takes into account the differences which are there in the national legal systems and taking those into consideration how this can be applied. Point D, what we find the provision and of effective and expeditious procedures for the multilateral prevention and settlement of disputes between the government and transitional agreements aiming at the fullest participation in the results of the negotiation. So, what we find it is not only how it can be implemented, but how if some disputes arise, what is the effective measures to solve it in an expedite in a fast way, and transitional arrangements aiming at the fullest participation of the results of negotiation. So, after the negotiations have happened, then how again to apply it and implement it. So, it is a action oriented steps taken starting from knowing the principles, finding out what are the basic standards it can be applied, finding out again like what are the processes to be done, then how if disputes arise, then how it can be solved quickly, and after the whatever agreement is done, how it can be again applied very quickly to the concern of the member nations. So, now we will see what is the nature and scope of the member countries, and we will see like as mentioned in article 1, here we are in this discussion we are putting forth exactly what is mentioned in the agreement. Members shall give effect to the provisions of this agreement. Members may but shall not be obliged to implement in the law more extensive protection than is required by this agreement, provided that such protection does not contravene the provisions of this agreement. So, what we see like whatever is determined by the agreement, members have to give effect to this agreement. They may or may not give more extensive protection that is required by the agreement, and the more protection, if given, if some member country decides to give it, should not be contravened, should not be contrasting, or should not like block the provision of this agreement as we were discussing, because should not be hampering the balancing act of this agreement, so that legitimate trade also takes place with the other countries. Members shall be free to determine the appropriate method of implementing the provisions of this agreement within their own legal system and practice. So, something generally stated in the agreement, but how to apply it, how to implement it, what is the how to execution of that plan of the agreement will depend on their own legal systems and practices. For the purpose of this agreement, the term intellectual property refers to all categories of the intellectual property that are the subject of sections 1 through 7 of part 2. Copyrights and related rights, trademarks, geographical indications, industrial designs and patents. In the last discussion, we have already discussed about these in details, about the details of these intellectual properties and their characteristics and how they are different from each other. Members shall accord the treatment provided for in this agreement to the nations of other members. So, in respect of the relevant intellectual property right, the nationals of other members shall be understood as those natural or legal persons that would meet the criteria for eligibility for protection provided for in the Paris Convention, the Berne Convention, the Rome Convention and the Treaty of the Intellectual Property in respect of integrated circuits, were all members of the WTO members of those conventions. So, in this Paris Convention, Berne Convention and the Rome Convention have given certain criteria for eligibility of protection, and the other members of other nationals, other members should meet those criteria, eligibility criteria, and will be considered as those natural or legal persons who meet these eligibility criteria for protection as provided in these three conventions. Any member availing itself of the possibilities provided in paragraph 3 of the article 5 or paragraph 2 of the article 6 of the Rome Convention shall make a notification as foreseen on those provisions to the Council for trade related aspects of intellectual property rights. Why was then TRIPS included in WTO? So, why it got included? What is the idea behind inclusion of this? Let us visit that. General Agreement on Tariffs and Trade, which was a precursor to the WTO, had already resulted in low tariffs and increasing trades amongst nations, due to which even domestic policies of the nations came into focus of trading nations. Developed countries, including the United States, started facing increasing competition in manufactured exports from newly industrializing countries of Asia. Developed countries as they were facing this increasing competition, then for issues concerning intellectual property rights, these countries were required to clarify GATT provisions and elaborate as appropriate new rules and disciplines in order to reduce distortions and impediments to international trade. As the role of technology became much bigger, having higher proportion of inventions and designs, IPR gained a dominant role in the trade amongst nations globally. As a result, in the Uruguay round of negotiations, the intellectual property rights dominated the discussions. As we understand, there is more trade happening. It's becoming open. Others are coming to know about us. We are coming to know about others. Then what happens then? And due to this, more inventions taking place, more designs coming into platform. So, the intellectual property rights and its protection becomes very dominant discussion in this platform. Now we have to understand which intellectual property rights are covered under TRIPS, because can we protect every intellectual property? If we can protect, to what extent will we give the protection so that the barriers in trade doesn't happen? So, how to balance for this? What all products should be given the IPR and all is a discussion, ongoing discussion with pros and cons for each, and we are focusing on that now. So, what we find, copyrights and related rights, that is the rights of performers, producers of sound recordings and broadcasting organizations, trademarks including service marks, geographical indications including appellations of origin, and industrial designs are the IPRs which are covered under TRIPS. Also, the patents including the protection of new varieties of plants, layout designs, topographics of integrated circuits, undisclosed information including trade secrets and test data. What is the link now between the TRIPS and WTO? WTO, through the TRIPS agreement, provides rules for trade and investment in the ideas and creativity by incorporating standards laid down in certain exact provision of the major IPR conventions. The WTO provides the intellectual property should be protected when trade is involved. Thus, through the TRIPS, the WTO makes it mandatory for all its member countries to follow basic minimum standards of IPR provided for under TRIPS and bring about a degree of harmonization of domestic laws in this field. So, centrally when it becomes mandatory to follow something, then whatever local differences are there, somewhere it comes to be like balanced in a common platform, so that exchange of intellectual properties and trades can happen. Now we will discuss about one of the important declaration, which is the Doha Declaration, which is for public health. It is a very important declaration, which is like when we are talking of on one side having intellectual property rights and protection of it, and at the other side looking at the public health and greater interest of the public at large. The Doha Declaration is very important in that respect. The framework of the rigid intellectual property rights established by the TRIPS agreement allows pharmaceutical manufacturers to charge prices above marginal cost of production. These affects the ability of the governments to monitor and protect public health because of their obligations to protect the IPRs of these medicines producers. So, on the one way, like they are allowed to charge prices above which is marginal cost of production, and because that right is given to the pharmaceutical companies, the government like is not somewhat gets restricted in their ability to monitor the and protect the public health because of their obligation to protect IPRs of these medicines producers. So, it becomes as a sort of like conflict of interest, like should I be more focused towards the public health and its concern, or should I focus towards the protection of the IPR of the medicine producers. This in a way restricts the ability of the government to ensure affordable access of these medicines to common public. This becomes more important in case of like maybe very important or crucial diseases. If the drugs become high priced, then people suffering from those diseases may not be able to access those things. In order to come over these issues, mainly with reference to the developing countries regarding limited or no access to medicines for affordable prices, the WTO members agreed to issue the Doha Declaration to clarify the TRIPS agreement in the context of public health. So, this is where we see, maybe when we have already discussed about utilitarian aspects in our past discussions, which talks of the greater good of the greater number, and maybe some are not looking into a collective good, and some are not looking into the maybe the good or the right of a particular individual or a group of individuals. This is where we see the interplay of these two theories, where the right of a particular medicine company is more important, or whether it is the good of the society at large is more important. These two comes like in important points of discussion over here. The declaration made it clear that TRIPS agreement does not restrict its member countries for taking steps from to protect public health, and give them the right to create exceptions to its IPR laws to enable to grant compulsory licenses for manufacture of essential goods such as life-saving drugs, even if the consent of the holder of the IPR is not forthcoming. But it was on the countries to decide when the compulsory licenses can be granted or determine situations of national emergency. So, what we find over here, like when it comes to the decision about the greater public at large, public health at large, so here the right is given to the countries, member countries, to give manufacturing licenses to other companies, even if the consent has not yet come from the company who is holding the IPR. And more so, these are important in case of life saving drugs. However, it depends on the companies in the countries to when to give the licenses and can be granted, or to determine like if it is a situation of national emergency, then how quickly it can be done. So, how to enforce it, how to practice it, how to execute it depends on the particular country where this is for the discussion. Member states were also allowed to grant a compulsory license for limited export and import of medicines where the receiving countries lacks manufacturing capacity. This was decided based on the decision taken by WTO in 2003. So, this is also an important step where we find, like, if the receiving country does not have a manufacturing capacity for the life saving drugs and another country has it, then member states were also allowed to grant a compulsory license for limited export or import of medicines where the receiving countries lacks manufacturing capacity. Why? The major concern is the safety of the safety and health issues of the public at large. So, in this discussion we have focused on the trade related aspects of the IPR in general and why it is important to have IPR and how IPR can be used in a prudent way to keep a balance between the rights of the members who are the producers of these intellectual properties, also vis-a-vis to balance the major concern of regarding public health and other things where it needs to be like open, accessible to the public at large, specifically in case of public health where we have discussed about the Doha Declaration. In the next session, we are going to discuss about the application of TRIPS in India. Thank you.